Hi, and thank you for joining this webinar today. I'm going to talk about health and safety dismissals as a result of the coronavirus pandemic. So the health and safety of employees has suddenly become a widespread and complex problem. And for as long as the coronavirus remains prevalent, the workplace is potentially a serious and dangerous place for employees, especially those who are elderly or vulnerable. We are expecting, as a result, an increase in the future in the number of claims brought in the Employment Tribunal for unfair dismissal as a result of health and safety. So under the Employment Rights Act 1996, an employee has the right not to be unfairly dismissed or subject to any detriment by the employer on the grounds that the employee has done any of the following. So if the employee has carried out activities to prevent or reduce risks to health and safety at work, if the employee has raised a concern about circumstances at work which the employee reasonably believes to be harmful to health and safety, if the employee leaves the workplace or refuses to return to the workplace because they reasonably believe there is a serious and imminent danger in the workplace, or where the employee takes appropriate steps to protect themselves or others from the danger in circumstances where the employee reasonably believes there is serious and imminent danger. So there must be a danger which the employee reasonably believes to be serious and imminent. So there doesn't actually have to be serious and imminent danger, and it doesn't matter what the employer's opinion is. What matters is what the employee reasonably believes at the time. And as the coronavirus regulations state that the coronavirus constitutes a serious and imminent threat to public health, it may be held that an employee is entitled to believe that they are in serious and imminent danger from contracting coronavirus in the workplace. An employee can also take appropriate steps to protect themselves from this serious and imminent danger. Whether steps are appropriate depends on all the circumstances, including the knowledge available to the employee at the time. So if you consider a situation where an employee notices that a colleague is coughing, has a persistent cough and is feverish, that employee might reasonably believe that the colleague has coronavirus and they're in imminent danger of contracting coronavirus. They may leave the workplace, and that may be considered to be an appropriate step. Or consider a situation where an employee insists on working from home because she hasn't been provided with a face mask. And in that situation where an employee has been unwilling or unable to provide a face mask, and then that employee goes home and refuses to return to the workplace, this may be considered to be an appropriate step. If the employee is then placed on furlough and put on 80% of salary, the reduction in pay is likely to be held to be a detriment, entitling the employee to claim compensation. So a dismissal or a detriment as a result of health and safety may be classed as an automatic unfair dismissal. Now, an automatic unfair dismissal claim is much easier to prove than a normal unfair dismissal claim. To claim for unfair dismissal, an employee is required to have a minimum of 2 years service with the employer, and the Employment Tribunal will consider whether the employer acted reasonably and fairly in dismissing the employee. If the Employment Tribunal finds that this wasn't the case, the employee is then entitled to compensation, which is capped currently at just under £87,000. With automatic unfair dismissal, an employee is protected from day one of employment, so there's no qualifying period of employment. Furthermore, the employee doesn't have to show that the employer acted unreasonably or failed to follow a fair procedure. As long as the employee can show the Employment Tribunal that there was an automatically unfair reason for dismissal, such as a health and safety reason, the dismissal will be deemed to be automatically unfair. Furthermore, the employee will be then entitled to uncapped compensation. So the employee may be awarded unlimited damages calculated on the loss the employee has suffered because of the detriment, as well as potentially an award for injury to feelings. So this means that in the future, employees that have only been employed for a short period of time may be making claims for unlimited compensation in a time where unemployment is high and it's difficult to find alternative employment. We also anticipate there will be an increase in constructive dismissal claims for health and safety reasons. So there's an implied term in all contracts of employment that the employer will take reasonable steps to ensure the safety of their employees. If the employer fails to protect the employee's health and safety, the employee is entitled to resign in response to the employer's conduct. So although the employee will have resigned, it will be treated as a dismissal as a result of the employer's fundamental breach of duty, and the resignation is then deemed to be constructive unfair dismissal. So if the employer's fundamental breach, such as suspending an employee, is in retaliation for the employee doing a protected act, such as leaving the workplace for fear of contracting coronavirus, and the employee resigns in response to this fundamental breach, this is likely to be classed as automatic constructive dismissal, where the employee can claim unlimited damages no matter how long they've been employed by the employer. So I think it's fair to say that when Parliament enacted the relevant sections of the Employment Rights Act 1996, they probably didn't have a global pandemic in mind. Each of the provisions is wide in scope, and it'll require employers, employees, and ultimately employment tribunals to make difficult decisions about workplace relations in the time of the coronavirus. There'll be questions such as, when is it reasonable to think that danger is imminent? What is an appropriate step for an employee to take in circumstances when they believe they're in danger of contracting coronavirus? Ultimately, these are questions that will be answered by employment tribunals, but in the meantime, we all need to consider certain questions which affect us all, such as to what extent are employees expected to bear an increased risk of danger at work, and how far are employers expected to go to prevent employees from this risk. So I hope that's been useful, but if you do have any further queries or need any further assistance, don't hesitate to contact me on the telephone number or email on the screen, and thank you for listening to this webinar.